I guess I just want to add a couple of thoughts about what we were just talking about. And I guess my bottom line thought is about if we look at cases where just in the conversation that we were just having about sort of, is it about the intrinsic value of life, or is it about ideas of rationality and consent and decision making and autonomy and all those kinds of things? And so there may be cases, there may be judges who have sort of, they think it's about this, and another judge thinks it's about that, or in a given case, or in a given case, a judge may say, the rationality idea is really the best way to think about this versus another way. And I guess what I'm wondering is whether, sorry, hold on just a second, whether you see those as sort of inconsistencies in dignity jurisprudence, or does that make the body of law sort of incoherent? Because in one case it's going to be about this, and in another case it's going to be about that? Or do you see it as not being incoherent, but that dignity has all these different facets, and just like, you know, pretty much any other concept in law, property can be lots of different things. And you may have cases where there's a conflict between intellectual property and real property or something like that, just, you know, and so on the one hand, you could see these as showing the incoherence of this body of law. And on the other hand, you could look at it and say, no, it doesn't mean that it's incoherent. It just means that it's complex, and it's, you know, going to be somewhat messy, if you will, because it's law trying to deal with really, really difficult problems. And so we shouldn't expect sort of one single rule that's going to cover every situation. So I just want to sort of ask that either as a rhetorical question, just something to think about, or if you have opinions, I'm happy to hear them. But I just wonder about that. And I think, yes, it is. Thank you. I think also some of these inconsistencies are really just baked into dignity law. And two sort of different kinds of examples came to mind in the context of what we were just talking about. One is the UDHR itself, right? Which sort of says it's just about the intrinsic worth of human life, right? Every human life has worth. Every human life has equal worth. It's just about that, right? Faith in the inherent dignity. And then you get this second sentence in Article 1 that says, all human beings are endowed with reason and conscience, which makes you think that really they're talking about dignity as this idea of rationality, as this idea of decision-making and autonomy and being able to make choices for yourself. And so right there at the beginning of sort of dignity studies, they're saying things that I think they think are coherent, but in fact, in the given circumstances of a case, may lead to different results. And then the other thing I just wanted to ask you about, and I don't know nearly as much about Indian constitutional law as you all do, but when we're talking about either the situation of euthanasia, where somebody is alive, but we might say the quality of life is not completely full, right? Or on the other hand, if we're talking about abortion or childbirth in a situation where the child may not have many opportunities to thrive. And I'm reminded of the language from Francis Corley Mullen, which says, you know, it's more than just mere existence. So when we talk about dignity, when the Indian Supreme Court talks about dignity in the context of Indian constitutional law, we shouldn't say dignity is just about merely being alive. We should say it's also about thriving and having all these other things. And I mention that not to suggest that there is a clear answer to this or that that case provides an answer. Certainly, I don't think the case was thinking about these issues. But more just to say, look at those inconsistencies sort of in the heart of dignity law, right? And that we have to, if we're going to study this area of law, we have to be comfortable with some level of just different ways of looking at it. And when you spin the diamond around, it looks different. The colors are different. So I just think that sort of the conflicts that you were just talking about are not necessarily just in those cases. Those cases are really good illustrations of it, but not, but they arise everywhere. Okay, so we thought we would sort of adjust the schedule a little bit because, in part because of, I think I can use the mouse here. We thought we would adjust the schedule a little bit, in part because after class yesterday and then even more this morning, we realized that the interests of the class were not specifically just focused on criminal law, but really, I mean, your ideas about the projects you wanted to do were, I'll just say, just fantastic and very, very broad. And so we just wanted to sort of fan out a little bit from the tighter focus on criminal law that we had originally anticipated. And also several of you were interested in children's rights. And I had mentioned, and children's dignity, and I had mentioned it a little bit, I think on the very first day, but then we thought it might be a good idea to sort of spend a little time focusing on it. What I'll do today is just really walk through international law protecting children. How many of you are familiar with the Convention on the Rights of the Child and principles of sort of child protection law? Okay, so this is pretty new. Okay.
No, I don't think so.
What?
Familiar with that. Not in depth, but like we know about the.
Okay, it's not the first time you've heard. Okay. So as with a lot of this class, we're talking about things that you may be familiar with from other contexts, but looking at them specifically through this dignity lens. And in that way, we're sort of going deeper, but also just sort of focusing on now. Let me just see how to advance this. Okay, I can just do this right there. Yeah, that's fine. Is it you?
Where is that pointer? Slide more.
Doesn't matter. I can do it this way. Okay, so the first thing I want to do, what I'm going to do is just talk to you about the Convention on the Rights of the Child, because that is just the gold standard of child protection law. And as I mentioned the other day, it has been ratified by every single nation on earth except the United States. I tell my students that 2015 was an important year. I give them the exact date, which I don't remember now, because on that particular date, I think it was Somalia that ratified it, which left us, the US, being the only country that had not ratified it. But okay, but nonetheless, it is the gold standard, and it has been incorporated into domestic law, sometimes explicitly sort of by incorporation, and sometimes implicitly just by adopting those rules. And in fact, in the US, much of what's in here is in fact in US domestic law, but not all. So I want to walk through the Convention on the Rights of the Child, focusing on the specific issues, on the specific places where dignity is relevant. And then I'll talk about how it's been interpreted and specifically the language about the best interests of the child, that standard of the best interests of the child. Thank you so much. Okay, so the preamble. We've talked before about the preamble in the UDHR and in the International Covenant. So here too, same thing. You get the same language, and it's doing the same thing. It's sort of saying this convention builds on past international law, international human rights law, considering in accordance with the principles proclaimed in the Charter, recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Sorry for going fast, but you already know this language. You've seen it before. And bearing in mind that the peoples of the United Nations have, in the Charter, reaffirmed their faith in fundamental human rights and in the dignity and worth of the human person. And I do believe that where they say dignity and worth, they don't mean two different things. They just mean to sort of reinforce dignity and worth of the human person, and have determined to promote social progress and better standards of life and larger freedom. Again, this reincorporating the language from the United Nations Charter and the UDHR, several things that we talked about before, but you see that these are the pieces that this convention is picking up. The dignity is inherent, that it's connected with the inherent worth of the human person, that it is equal and inalienable in every human being, and that it's the foundation of freedom, justice, and peace. It's not just one of many values, but really sort of the core value in the human rights edifice. And this, what I call sort of this transformative or aspirational or progressive aspect of dignity, the part of the work that it's doing is to move things forward, to make things better so that more people can live better lives, right? That is the purpose, in a way, of founding the human rights regime on the idea of dignity, is that dignity is the basis and also the purpose to allow more people to live with dignity. So those ideas that we've seen before are picked up here again. Probably the most important provision in the Convention on the Rights of the Child is in Article 3. In all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, in other words, in all actions concerning children taken by the state, the best interests of the child shall be a primary consideration. I love that language, a primary, because it just seems right out of the box to be contradictory, right? It's one of many primary considerations, but we're not telling you what the others are. So it's really important, but we're not telling you how important it is. But we do know that it is important. Dignity shows up in several other provisions in the Convention on the Rights of the Child. I haven't looked at this. I don't know if this is actually true, but my sense is it's probably explicit here more often than in any other of the major human rights conventions. That's at least close to true. I don't know if it's absolutely true by counting, but Article 28 requires state parties to take all appropriate measures to ensure that school discipline is administered in a manner consistent with the child's dignity and in conformity with the present convention, right? So looking at school discipline, where historically throughout the world, many violations of human rights have occurred in the name of school discipline. And this is one of those pieces in human rights law where we're looking, where dignity is actually trying to make an explicit change, sort of these pivot provisions, where kind of like I think the untouchabilities provision in the Indian Constitution, where the language is just saying, I know it's always been done this way, we're going to pivot and do something different now in line with human dignity. So you see it here in Article 28, also in Article 37, which concerns children who have been deprived of liberty, right? Children in conflict of the law, children who are institutionalized or incarcerated in one way or another, shall be treated with humanity and respect for the inherent dignity of the human person. Again, suggesting dignity as a mark or signature of humanity. And to me also, what's interesting about this provision about children who are deprived of their liberty is that what they're talking about is the inherent dignity, not of the child, but of the human person. In other words, they're generalizing. They're not saying children have special and different dignity. They're saying children are people too, right? And if all people have dignity, children are included in that, so they get the same respect for their dignity as any other person. Two provisions dealing with children and the law. One in Article 39 concerns victims of abuse, mandates the recovery and reintegration of children shall take place in an environment that fosters the health, self-respect, and dignity of the child. And again, I would encourage you, when you see the word explicitly, either in constitutional provisions or in constitutional texts in jurisprudence, to look at the words that are around it, right? Dignity and worth, dignity and equality, dignity and rights. Here we're looking at health, self-respect, and dignity. A lot of you in your sort of pre-class statements about what dignity means referred to the concept of self-respect. And here it is in the Convention on the Rights of the Child. Article 40, children in conflict with the law. Every child alleged as accused of or recognized as having infringed the penal law must be treated with a promotion of the child's sense of dignity and worth. Here we're not talking about the child's inherent dignity, but their sense of dignity, the sort of the psychological aspect of dignity. And some of you in your pre-class statements refer to that also. It's not just your intrinsic worth, it's how you feel about yourself. It's this psychological aspect, and the penal law should not diminish children's own sense of their own self-worth. Sense of dignity and worth, which reinforces the child's respect for human rights and fundamental freedoms of others, and which takes into account the child's age and the desirability of promoting the child's reintegration and assuming a constructive role in society. This aligns with notions in the penal law generally, not just about children, but about everybody, that suggests that of the various purposes of incarceration, only reintegration and rehabilitation is consistent with human dignity, that retribution or deterrence really are not consistent with human dignity. And this aligns with that. This sort of falls into place with that more general understanding about the penal law, that the purpose of depriving somebody of their liberty after they have committed a crime is to eventually get them back into society where they can live with dignity. And then in Article 23, a mentally or physically disabled child should enjoy a full and decent life in conditions which ensure dignity, promote self-reliance, and facilitate the child's active participation in the community. So again, children with different abilities and recognizing their rights to dignity. And again, here it's a different sort of concept of dignity. It's not the inherent worth of the person. It's not their own psychological sense of self-esteem. It's living a full and decent life. It's that basket of rights that's about living with dignity, right? And ensuring and sort of affirming that children have a right under international law to live a full and decent life with whatever their abilities are, and promote self-reliance. And you see also what we were talking about yesterday, this sort of fluidity between living a full and decent life, that sort of living with dignity idea, and facilitating the child's active participation in the community, right? So sort of that fluidity between social and economic rights and political rights, if you will, that notion that living a decent life, having the means to live more than a mere animal existence, allows you not only to fulfill your personality and develop, but also allows you to engage, to participate, to belong to a community in an active and full kind of way. So I wanted to include some of this so that some of you are working on things that either directly or indirectly sort of touch on these, and I wanted you to see these. Article 12, I don't have the article up there, but it's Article 12. I think is one of the most interesting provisions in the Convention on the Rights of the Child, probably, to my mind at least, the most interesting. It's the right to be heard. And I think it's interesting because, frankly, I haven't seen it elsewhere in human rights law as such. There are rights to participate, there are rights to speak, but you don't really see the right to be heard. So it's interesting to see it included in this convention, and specifically, or especially interesting, because it relates to children. State parties shall assure the child who is capable of forming his or her own views the right to express those views freely in all manners affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. For this purpose, the child shall in particular be provided with the opportunity to be heard in any judicial and administrative proceedings affecting the child, either directly or through a representative or an appropriate body, in a manner consistent with the procedural rules of national law. So look at these two provisions here. The first just says, for the child who is capable of forming his or her own views must have the right to express those views freely in all matters affecting them. And that they should be, and that those views, it's not just, okay, you can stand up and say your piece, but we're not really paying any attention. Those views have to be given due weight, due being related to, how much weight is due is related to the maturity of the child, etc. And then secondly, they must be provided with the opportunity to be heard. So sort of an affirmative obligation, a positive obligation that a court has to make sure that a child who has the capability of expressing their views has the opportunity to do so. So it's not just a negative right, it's also very much a positive right. I should have said something at the beginning, and I'll just say it now. The Convention on the Rights of the Child defines child as anybody who has not attained the age of 18 years old. So just keep in mind that if we start human rights at the moment of birth, which is where the UDHR starts, at every person born a member of the human family, the rights in this convention affect every human being on earth from that moment of birth until their 18th birthday. That's, first of all, a very large number of people on earth. And secondly, it's a very wide range of people, right? Not just the normal range of people, like geographically and culturally and all that kind of stuff, but the range of people from literally a newborn to somebody who's about to celebrate their 18th birthday. And this convention is trying to address the rights of that whole very, very, very diverse group. So you get language like this: everybody shall have the right to express themselves, but of course a newborn is going to have a very different experience of that right from somebody who is 17 years old, right? And somebody who is 12 years old is going to be somewhere in the middle, right? So that language is trying to address that, trying to establish a clear right, recognizing that in any application there's going to be some room for adjustment. Okay, so let me go back to the best interest of the child. I just want to reread this language so that it's in your mind, because this is really the sort of the focal point of children's human rights law, is the decisions, all actions concerning children, I misread it. In all actions concerning children, the best interest of the child shall be a primary consideration. Okay, so that's the language, that's the essence of the right. So I want to talk a little bit now about how that's been interpreted. And there's both not enough clear articulation of what that right means and also too much. Like a ton has been written about it, but it's still sort of a concept that is in development, right? And in part because it arises and applies in so many different kinds of circumstances to so many different kinds of people. So how we think about the dignity of the person when they're 2 years old and what's in their best interest and who should be making that decision raises many of the same issues we just talked about, right? About people who are in one way or another incompetent or less competent to make those autonomous decisions for themselves. We're going to think about them differently, whether we're talking about a very young child or someone who's older. But it's the same test throughout that 18-year period. The best interest principle is a central building block of the Convention on the Rights of the Child. The application of this principle requires the development of a child rights-based approach designed to secure the holistic, physical, psychological, moral, and spiritual integrity and to promote his or her dignity. So what I've included in the PowerPoint, I've cherry picked, right? There's a whole lot out there about what the best interest of the child means. And I'm obviously focused on the definitions that both seem most holistic and applicable and sort of comprehensive, but also that connect the idea of the best interest with his or her dignity, their dignity. So here what you see is there's a few pieces of this language that I just want to draw your attention to. One is that increasingly, and UNICEF has been a very strong proponent of this notion of a child rights-based approach. So when we're dealing with a situation, with any kind of social situation or legal situation that involves children, we should use a child rights-based approach. It's a way of foregrounding the child, right? We're not just making a social decision and, oh, yes, it happens to apply to a child, but if it does apply to a child, we're going to make them the center of our attention. So it's a child-based approach and also a rights-based approach. So that best interest shows up not in a sort of descriptive tract about, a psychological or social work tract about what's good for children. It shows up in a legal convention. So it has legal significance as a right. So a child rights-based approach, which is quite comprehensive, right? It has to look at holistically at the physical, psychological, moral, and spiritual integrity of the child, right? So notice sort of how broad that is, how comprehensive that is. I don't think it's exhaustive. I think if one could rewrite it and add more different dimensions of the child's experience, but this is a starting point. And notice that it has to do with the integrity of the child. And that's a word that we haven't really seen that much. For those of you who are thinking about rights of nature, integrity is a really interesting word to think about as sort of a stand-in for dignity in the context of nature. So just flagging it for you there. And of course, the purpose of all of this is not only to maintain the integrity of the child in all its dimensions, but also to promote his or her dignity. I have a few other sort of alternative formulations of the best interest of the child, and I want to go here. This is actually a case about how it's applied in England and Wales. It's not terribly relevant. It's not terribly applicable, but I use it because it was adopted by UNICEF. I mean, in one of UNICEF's publications about this, it sort of picks up on this language. And also, I just think it's a particularly well-crafted and comprehensive understanding of best interests. Evaluating a child's best interests involves a welfare appraisal in the widest sense, like what is the child's welfare in the broadest sense, taking into account, where appropriate, a wide range of, and here you're going to get another list of dimensions, slightly similar, slightly different: ethical, social, moral, religious, cultural, emotional, and welfare considerations. So when you're considering what the best interest of the child is, you have to look at the child in all of those dimensions. Everything that conduces to a child's welfare and happiness or relates to the child's development, remember that language from dignity law about the full development of the personality, especially applicable, of course, when we're talking about children and young people. Everything that conduces to a child's welfare and happiness or relates to the child's development and present and future life as a human being, including the child's familial, educational, and social environment, and the child's social, cultural, ethnic, and religious community, is potentially relevant and has, where appropriate, to be taken into account. The judge must adopt a holistic approach. So again, you see sort of a reiteration and reaffirmation and reinforcement of these ideas. So what UNICEF has done is articulated in its child rights-based approach several ways of thinking about the rights of the child, mainly derived from the Convention on the Rights of the Child, but also whatever else has sort of become part of child's rights laws. And what you'll see here is this is the way UNICEF organizes children's rights. And you'll see it maps on sort of, not completely, but similarly to sort of the three baskets that we've been talking about the last couple of days in terms of dignity rights. So this child rights-based approach UNICEF doesn't emphasize dignity as a measure of the best interests of the child. It doesn't do that explicitly, but I think it does that sort of implicitly. It does that in certain ways. We've seen references to it. And then when it develops the idea of exactly what rights are we talking about, you can see it sort of maps on very much to what we've been talking about. So the first category is provision rights. For example, these are the rights that the state must provide to a child. For example, health, education, play, social security, an adequate standard of living, support for parents' family life, including non-separation except when in the child's best interest, care, and adoption. So the state must provide all of these things, or at least opportunities for these things. Like in the case of play, it doesn't have to force the child to play, but it has to make sure that a child has an ability to play, right? So when we think about childhood exploitation through labor, through trafficking, through other things, one of the things that's missing there that is a recognized right is the right to play. They're also aware that in the typical situation, it will be the family that provides a lot of this, right? The family that ensures that the child goes to school, the family that ensures that there's an adequate standard of living, the family that does all that. That's the typical situation. But of course, UNICEF is acknowledging that that's not always the case. And there may be cases where, while the presumption should be in favor of non-separation, that a child stays with their family and is raised by their family, it acknowledges that there are certainly cases where it's in the best interest of the child to not do that, right? So this is the language that they're using to sort of, again, it's very like concise language to deal with all these really complicated situations, right? Secondly, protection rights. For example, protection from violence, economic and sexual exploitation, protection from harmful drugs, armed conflict, torture, inhuman and degrading treatment, illicit transfer and non-return, and access to child and protection rights that includes access to child-friendly justice systems, as well as protection of refugees and children with disabilities. So again, this is like protection from all the worst horrible things that a child can experience or be a part of. Under a child rights-based approach, the child should be protected from all of those. And some of those are direct exploitation of children and abuse of children. And some of them are, I would say, more sort of situational, like armed conflict. Doesn't necessarily have to involve the child directly, but if the child is living in a situation of armed conflict, their rights are being deprived. They're being deprived of their rights. So provision rights, protection rights, and then third, participation rights. For example, and look at these rights of participation. For example, birth registration, name and nationality, freedom of expression, religion, association, information, privacy, evolving capacities, and the right to be heard. So some of those consider sort of active participation, like the right to be heard, freedom of expression, association. Those are things a child should have the right to do or engage in as part of belonging in a community and participating in decisions that affect them. And some of those really go much more to just pure identity issues, right? Name. Every child should have a name. Every child should have a nationality. Every child should, where you live in a country where there is the registration of birth, every child should have that capacity to be registered. So again, without mentioning dignity, you can see some of these go directly to what we've talked about certain aspects of dignity, and some of them sort of more indirectly, but still going to the various aspects of dignity that we've been thinking. So I think maybe what we'll do, if anybody has any questions about this so far. Maybe what we'll do is break for tea. All right. So that was all sort of giving you the background, laying the groundwork, showing you sort of how children's rights are thought about. I want to, I'm going to skip through some of the slides I have. So I want to focus on three things. So this is language, and I'll read it. It's from an Inter-American Court of Human Rights case that some of you, I think, might be familiar with. I'm not sure. I've talked to some students who are familiar with it, so I don't know. It's called Villagrán Morales versus Guatemala, and it's known as the Guatemalan street children's case because it has to do with children who are in situations of living on the streets. And which is obviously a very dangerous and dangerous place to be and a place where dignity is precarious. And in this case, there were some children that had died, and then there was the question of sort of what is the state's responsibility towards children who were in situations of living on the street. And it's a very well-known case because it is sort of the first case to say, to establish certain principles relating to children and relating to the positive obligations of states to protect people in vulnerable circumstances. So I'm just going to read this just so that you see it, and without going into the facts of the case any more than that. A person who in his childhood lives in the humiliation of misery without even the minimum condition of creating his project of life. I think I mentioned to you that life project idea is a prominent feature of human rights law in the inter-American system. In the humiliation of misery without even the minimum condition of creating his project of life, experiences a state of suffering which amounts to a spiritual death. These offenses render victims not only those who suffered them directly in their spirit and in their body, they project themselves painfully into the persons dear to them. In essence, the fundamental right to life includes not only the right of every human being not to be deprived of his life arbitrarily. So again, this is like the inter-American version of Francis Corley Mullen, that the right to life is not just about the right to be alive or the right to not be killed. And this is extended in this case and also in the international human rights law under the International Convention on Civil and Political Rights. In essence, the fundamental right to life includes not only the right of every human being not to be deprived of his life arbitrarily, but also the right that he will not be prevented from having access to the conditions that guarantee a dignified existence. States have the obligation, in other words, the affirmative obligation, to guarantee the creation of conditions required in order that violations of this basic right do not occur. Language from this court is often very, very hard to follow and very hard to understand. It's just a different way of writing in Spanish versus writing in English. I don't know how it would be if it was translated into Hindi. But you can see what's going on here, that it's more than just the right to life, but the children, that the state is obligated to create conditions, to ensure conditions that a child will be able to develop and to have some meaningful life project, right? So when we look at a child's rights-based approach, we're looking at the best interests of the child, and we're looking at children in part one of this is we're looking at children as people who have vulnerabilities, right? Young people who live on the streets have a multitude of vulnerabilities, right? But children in general, whether they live on the streets or not, children in general have certain vulnerabilities. And this establishes an obligation on behalf of the state, on the part of the state, to protect children against those vulnerabilities. What I want you to sort of think about, if you are interested in thinking about the rights of the child, is this idea that everybody is born equal in dignity. So that quantum of dignity, like what we were talking about yesterday when we were talking about equality and everybody has the same equality, well, from the moment of birth, right? And it's not that it exists at the moment of birth and then comes to fruition when you turn 18. It's that it's there with you all along, that same quantum, right? It's indivisible. You don't have less dignity at different parts of your life, but you do have different dignity rights at different parts of your life, right? So as much as we will say that all human beings from the moment of birth throughout their entire lives have equal dignity, we are going to say that people throughout their lives have different rights. And just think about this logically, right? There are certain rights that attach to infants from the moment of birth, right? The right to care, the right to nutrition, the right to bodily integrity. Now, that doesn't mean that children can't be handled without their affirmative vocal consent, but it does mean that that handling should be in their best interest, right? You treat a child in their best interest. You touch a child in their best interest. So from the moment of birth, there are certain dignity rights that attach, whether you call them sort of living with dignity rights or provision rights or whatever, it doesn't matter. You get these certain rights. And then as children grow, they gain more rights, right? Because these participation rights, the Article 12 right to be heard, obviously, well, babies have rights to be heard, I suppose, because they cry and that's what we hear. But they don't have that as an affirmative right, right? So that right to be heard, that right to participate, that right to express your views in a decision that affects you is going to come along at some point. It doesn't wait until you're 18, but it also doesn't happen right at birth, right? So it's evolving. And just like in these cases of incompetence or limited competence, what we saw before is that the law is going to require you to look at each child as an individual and say, you are actually quite capable of expressing yourself and expressing your opinion about what should happen to you. So we're going to make sure that you can do that. Whereas another child, and it's not necessarily specifically age dependent, it's not like all 10-year-olds can and 9-year-olds can't. But what dignity law requires is assessing the person on the basis of their own unique characteristics. So looking at the child and saying, at what point does your right to speak and your right to participate in decisions and your right to be heard come into effect such that it needs to be respected in order for your dignity to be respected? Or in other words, if we don't give you that right, are we violating your dignity? Maybe not with most 3-year-olds, maybe yes with most teenagers. So we think about it. Certain aspects of identity, like name and registration, apply from birth, but other aspects of identity, like how you dress, who you're friends with, what maybe in some circumstances, what religious beliefs you want, attend at some point later. So identity formation and full development of the personality are going to be things that kids consciously start to develop as their consciousness develops. And then at the point of turning 18, for the most part, all civil and political and social and economic and cultural and environmental rights attach to the person who is then no longer a child. So I think this is like really obvious and really intuitive and really straightforward, but it's actually conceptually quite complicated, and in application, it's quite complicated, right? Conceptually complicated just in the sense that dignity in its fullness attaches at birth, but dignity rights develop later. So it's the one time that we're really asked to distinguish between dignity and rights. And then in the circumstances of any given case, figuring out what's in the child's best interest, or at what point should they have the right to be heard or express themselves or have any of these other rights, needs to be figured out in the context of the individual case. I did put right at the bottom, girls and boys have different experiences, but also I just want to sort of make that point without going into more detail about it. Because I think in any given application, in any given situation, we want to pay attention not just to sort of the gender identity of the person, but also the cultural identity of the person being of one gender or another or a third gender or something else. So we generalize and we talk about children's rights and the best interest of the child, and we act as if a child is a generic thing. But in fact, in any given situation, obviously the particularities, but also the gender differences are going to affect things. The point that I just want to make really sort of importantly is that what we see when we look at the Convention on the Rights of the Child and then its later interpretations is this evolution in how we think about children. So we start thinking about children as victims, like in the Inter-American case, right? They're victims, they're on the street, the state has to protect them, right? That case doesn't talk about what each child wants. The case talks about what the state needs to provide to this victim of a child. Sometimes we talk about them as perpetrators when they're in conflict with the law, and then we also treat them as we have to figure out what rights they have and what to do with them, and the whole question that we looked at before about what to do with children who are deprived of their liberty or other things like that. Then the evolution is such that we then look at the whole person, and we looked at that language, the interpretations of the best interest of the child, that holistic language, looking at their spiritual and moral and educational and emotional, all those things. So that's sort of a jump. First, we're looking at them as just these helpless things that we need to protect. Then we're looking at them as people that we need to sort of understand all their various needs. But most conceptions of the best interest of the child still looks at the child as this object that the state or the adults around them need to figure out how to provide for, right? And the jump between the first and the second is just, let's look at them more holistically as a whole person. And that is part of, dignity speaking, is looking at a person in their entirety, not just in one dimension. But what's really interesting is that current interpretations and applications of the rights in the Convention on the Rights of the Child take this notion in Article 12 of the right to be heard really seriously. And increasingly, you see references to treating the child not as a victim or even sort of as the object of state policy, but as an agent in their own right. So this isn't so much about the growth of the child as much as the growth of the law, right? The law is now seeing children, people under 18, could be of any age under 18, as agents in their own right. And it's an important point if you're interested in children's law, because that's sort of where the law is moving more and more. But I think it's also an important point, and I want to make this point after hearing your presentations this morning, that it's an important point to think about people in vulnerable circumstances under any conditions. So what we're talking about now is people who are in vulnerable circumstances because they're still developing, they're younger, they don't have full capacities, etc. So that makes them sort of vulnerable, and we have to think about that. But the idea of saying, yes, they're vulnerable, but they're not just victims, and they're not just objects, they're actually agents. And they have that dignity right to not just to participate in community, but to make decisions for themselves. They have that developing autonomy. And I think that increasingly applies to other situations of people in vulnerable circumstances. So whether we're talking about people like in the abortion case that you were talking about previously, vulnerability because of lack of or diminished mental capacity, vulnerability in terms of various abilities that we have or don't have that make us more or less vulnerable to various different kinds of things, vulnerability of elderly people, vulnerability of all kinds of people. So I just want to, when you are looking at dignity in the context of these various populations where people are vulnerable for one reason or another, and most people are vulnerable in one way or another, I just want you to think about this sort of evolution and see that a strong commitment to dignity takes us from this notion of people who are in vulnerable circumstances as victims that we have to do things for